So let us start. Welcome everyone to another Belgrade Legal Theory Group meeting. Tonight with us is a great friend of mine and a great friend of the Faculty of Law, University of Belgrade, Paolo Sandro. Was here visiting us a couple of years back. Would like to see him soon again in Belgrade. Hopefully these times of normally visiting each other will come sooner than later. He's now a lecturer in the law at the Law School, University of Leeds. And the occasion for our today's meeting is the publication of Paolo's book, The Making of Constitutional Democracy from Creation to Application of Law. I'll send you a link for the book on the chat so you can order personally. The book is a defense of the distinction between creation and application of law within the structure of constitutional democracy. And while the book still hasn't reached the Faculty of Law in Belgrade, the second chapter that Paolo was kind enough to share with our students is more than enough to confirm the breadth of argument, the skillful combining knowledge from history, anthropology, political science, constitutionalism, constitutional theory, philosophy of language, and of course, philosophy of law. That Paolo drew together in defense of the central thesis of his book. I'm sure that the second chapter for those students who received it was an interesting read. As usual, Paolo will present his central claims and arguments in the first 30 minutes or so of the meeting, followed by 30 minutes of Q&A. The other rules have been already posted by my colleague Ana Zdravkovic in the chat, so you can inform yourselves of them. With this, I finished my brief introduction and I give the floor to Paolo.
Thank you so much for the very kind introduction, my friend, and hello to everyone in the room. It's good to see you, although I would have preferred to see you in person, all of you. As Bojan was saying, I certainly miss Belgrade, and I hope to be back soon. As Bojan know, I might be the legal theories with the biggest basketball passion outside Serbia. So it's for me it's always incredible to come back to Serbia and you know, where I feel at home in more than one way. Thank you also to all of you for being here. When I shared the chapter, I was really looking forward to hear your thoughts, because the book has been written not with only legal philosophers in mind. I was not interested in writing a book that only 30, 40, 50 people could understand around the world, let's say 100 perhaps. Unfortunately, I see a tendency in some types of current legal theory or jurisprudence to write books that are basically inaccessible for the non-initiated. And I find that that is problematic on a number of levels, among other things, because it does not do justice to legal theory. And what's the point of legal theory if only 10 or 15 people can understand? So I am incredibly welcoming, and I would really love to know what you guys, especially the students who are here today, thought if they read the book. Let me just share some slides that I prepared. So you should be able to see the slides, yeah? Yeah, thank you. So I don't plan to talk for more than about 20 minutes because I would really like to have more of a Q&A with you. What I plan to do today is just to give you a very brief overview of the contents of the book, in the sense that you have received chapter 2, which I thought was good because it could be of interest also for constitutional lawyers, for people interested in public law. But I want to give you a brief overview to start with about the rest of the book, the other contents of the book. And then I will highlight the two main points that I tried to make in the chapter you had. So hopefully even people that might not have read the chapter should be able to follow the discussion and participate in the discussion. The book has been a long time in the making, as Boyan knows, and it's the result of a project that started at the University of Edinburgh, where I did my PhD in legal theory. And actually, I want to tell you this because I think it might be good for some of you to hear on the basis of someone else's experience. This was not my original PhD project. I was writing about separation of powers and administrative judicial review. And then halfway through the PhD, I realized, okay, wait a second, I cannot write about this if I first don't deal with the distinction between creation and application of law. And so I completely pivoted. It wasn't fun. It wasn't pleasant. There was a lot of anxiety, but it happened. So especially if you are doing your PhD, these things happen. Trust your guts, trust your supervisors, especially as you have fantastic ones in Belgrade. And keep going at it, keep grinding, which in a PhD is perhaps, I think, the most important rule of thumb. So the book has 7 chapters overall. I start with setting the ground for the book, because I think that another thing that as legal theorists we must do in doing legal theory and jurisprudence nowadays is be clear about what we set out to do when we write, whether the inquiry is explanatory, is conceptual, is normative, what is our frame of reference, what is the context that we are dealing with, what are the limits of our enterprise. And so I try to do this in chapter 1, in which basically I follow, I think, one of the most important messages by Norberto Bobbio, the famous Italian political and legal philosopher, who was very clear that the theory of power is a crucial part of any theory of law, that there is a very close relationship between law and power. We cannot really talk about law if we don't talk about power. Then chapter 2 is the one you have, so I'm not gonna say anything about it. Chapter 3 is a chapter that if any of you attended the fantastic conference on judges and legal realism organized by Professor Spych and Professor Jovanovic, was it 4 years ago now, 5 years ago? In Belgrade, I presented basically the core of the argument from that chapter. Basically, it's a critique of what I called moderate legal realism, which is the legal realism defended in the last 20 years, let's say, by people like Brian Leiter from the University of Chicago or Riccardo Guastini from the University of Genoa. Basically, I say that there is no such thing as moderate legal realism. Either one is a realist all the way down or else. Chapter 4, I deal with the concept of discretion. I started in Italy as an administrative lawyer. My first PhD in Italy was in public law and particularly in administrative law. And I always found that the analysis of discretion in administrative law scholarship was much better than jurisprudence. I don't like Dworkin's account, for instance. I think the distinction between weak and strong discretion, it's only confusing. It doesn't really add much. So in this chapter, which is very long, I try to put together the jurisprudential and the administrative law scholarship discourses on discretion. These two discourses have been running parallel for decades, and I try basically to put them together, I try to come up with a concept of discretion that actually is helpful no matter where you look at it. Chapter 5 is the relationship between law and language. This is perhaps the most technical chapter in the book. I deal with the distinction between semantics and pragmatics, especially when it's applied to legal philosophy, to legal theory. And the main aim of the chapter is to criticize and ultimately argue for rejection of the application of Grice pragmatics to legal communication. I don't think that that's the right way to go for a number of reasons. Chapter 6 is where I draw all the strands of the argument together and I look at the distinction between creation and application of law. By the way, very quickly, why am I even bothering with the distinction between creation and application of law? Because if you think about it, especially when you start at law school, when you're a student, you either read on textbooks in judicial decisions that, you know, some people in our states make the law, create the law, legislators, governments, whatever, and some people apply the law, public officials, administrative officials, civil service people, judges, etc., etc. This is pretty unassuming, and we routinely use this expression without any issue. But then when you look at legal theory work, and particular analytical jurisprudence, you will find hardly any explicit defense of the distinction between creation and application. If anything, you find the opposite. You find people that say, well, look, really, there is no such thing as distinction between creation and application of law. And to me, that is very problematic because it is not just a matter of legal theory, it's a matter of political philosophy as well. If there is no such thing as a distinction between the activities of creating legal standards and applying those legal standards, then we have a massive problem with our current political practices. What is the point of democracy? What is the point of constitutional democracy? What is the point of having a constitution? That's why I ended up writing this book. If you look at the literature, there is literally no one. The one that goes closer to defending the distinction between creation and application of law is perhaps Joseph Raz, but even Raz doesn't really ground it. He says that we must presuppose the distinction, but it doesn't really explicitly ground it. In chapter 7, the final one, I show one application of my proposal, which is on the separation of powers doctrine. And in this chapter, I try to argue that we should abandon the Montesquieuian tripartite model of the separation of powers for a number of reasons. And we should instead look through the lenses of the activities of creating and applying the law when we're looking at the separation and or division of powers. So today I'm gonna, over the next 15 minutes, I'm going to talk about the two main things that I try to do in chapter 2, the chapter that you received. And the first one is what I've called the understanding, the definition, the conception of constitutionalism as legal otherness. What do I mean by that? In general, when we're talking about constitutionalism and particular constitutional democracy, there is a famous article, I think about 20 years ago now, or 15 years ago by Jürgen Habermas, which says, is constitutional democracy, asks rhetorically, is constitutional democracy a paradoxical union of contradictory principles? And there is, of course, a grain of truth in this, in the sense that if you take the ideal of democracy, you know, of course, there are different conceptions of democracy, but almost all of them, they have some version of majority rule at its core. And then you take the most common idea of modern constitutionalism, the idea of the limitation that there are certain things that no lawmaker can do, then basically there is an apparent or prima facie tension between democracy and constitutionalism. Now, the tension is prima facie. There is actually argument, there have been arguments made, Neil Walker has been one of them, to say that actually constitutionalism provides democracy with completeness. So actually there is also a relationship of complementarity between democracy and constitutionalism. But the problem then becomes the following. And this is where the paradox of constitutional democracy perhaps arises. The paradox is the following. If the idea of modern constitutionalism is or revolves around at its core the idea that government must be limited, and again, very few people, yes, there are some some authors recently there are, highlighting the fact that constitutionalism does not only limit but also legitimate political authority, and that is absolutely true. But it's hard not to understand modern constitutionalism as the idea of limits to what the government can do. But then the problem is that how can government be legally limited if law is the creation of government itself? And of course, this was a problem that, was on the forefront of political philosophers for quite a long time. I discuss some of them in the chapter. And the solution to the paradox that we collectively found, especially after the revolutionary movement in France and in the US, a couple of hundred years ago, is the solution of having a constitution, having a codified, entrenched constitution that sits above ordinary politics and ordinary legislation. I mean, here you can see a picture of the US federal constitution, which is usually brought as the typical example. The problem is that because constitutions have become so crucial to the idea of constitutionalism, and we've seen this particularly in the second half of the 20th century, after the Second World War. We even talk about, in comparative constitutionalism, we even talk about this exceptional spreading of constitutional ideas and constitutional forms of government all around the world in the second half of the last century. The problem with this is that the way, at least I understand it, the way I saw it, is that an unwarranted equation appeared in constitutional theory, which is the idea basically that, the realization of constitutionalism, of the political doctrine of constitutionalism, appears to be the same as the presence of a codified constitution in a given system. Basically, in a lot of work, if you look at constitutional theory in the last 40, 50 years, you will see that, well, if there is a constitution, then that's enough to say that that's a constitutional state. It's enough to say that that state, pursues constitutionalism, if you want. This has two implications. And for me, both of them are problematic. The first one, if a state has a codified constitution, regardless of its content, then that state ought to be considered a constitutional one. Again, merely because there is a constitution, no matter what the constitution says or how the constitution is applied, because of course that's also crucially fundamental, as we saw, for instance, right now with Russia. Russia has a entrenched constitution that on the face of it looks pretty fine, looks pretty good, there are rights, etc., but then the reality is very different, of course. Second, and this is also perhaps even more interesting to me as a continental lawyer who then moved to the UK, is that the UK does not have a constitution, a codified constitution, of course. Does that mean that the UK is not a constitutional state? That would be incredibly weird, because for a long time already, and correctly in my view, as I will explain in a second, the UK is identified as the birthplace of modern constitutionalism. The very idea of limited government is born in England, all right? And I will go back to this in a second. So for me, the issue lies in the coupling of the doctrine of constitutionalism with the presence of a constitution or lack thereof of a constitution. We need to decouple the two things. It's a sad breakup, but we need to do it, in my view, in order to better understand how constitution works and how constitutionalism is supposed to work. In my view, what constitutionalism as a political doctrine requires is the limitation of law by law. It is not just any type of limited government, but is the limitation of law, the law produced by parliament, by the sovereign, by government, whatever, limited by a different type of law. The problem then comes back, the paradox. How can you have constitutionalism without a constitution, though? Where would the limitation of law by law come from? And this is where I think we must go back to the UK common law model. Now, I won't go too much into detail, but I'm more than happy to explain this in the Q&A. In the last 10 years, basically, what happened is very interesting. I moved to the UK 12 years ago thinking the UK didn't have a constitution and was, you know, absolutely, that was wrong, that the UK should have had a constitution, a codified constitution. And then progressively, I understood what the common law system means, how it evolved and how it provides the limitation of government. So what I argue in the chapter that you have is that what we have witnessed in the history of Great Britain, of the UK, is that a type of law that is not available for Parliament, for the Westminster Parliament to dispose of, was created and nurtured and developed by judges. And so in the book, I try to underscore the crucial distinction between law as lex, law as the product of political authority, the legislation by Parliament, and law as use, this different type of law that has been created on the basis of customary rules, but which is independent from the will of the political sovereign, at the core, at least. This is true with the common law in the UK. Clearly, the UK model of constitutionalism, unlike codified constitutional models elsewhere, the American, the German, the French, the Italian, and so forth, it's much more reliant on the trust and the mutual respect between constitutional actors. Why? Because there is no fixed terms of reference as to the rules of the constitutional game. So, of course, the fact that we all abide the customary conventions, so to speak, so those political and moral rules that are supposed to give us the rule of the game, it's even more important in the UK. So basically, in the book, I try to show that any type of constitutional democracy at its core has a dualist structure. And the dualist structure is the tension between two different types of law as lex, which is law as the product of political authority, and law as use, which is a different kind of law, which could either be entrenched in a constitution. So modern codified constitutions are not are anything else than the entrenchment of this second type of law above ordinary legislation, above law as lex. And law in use, of course, has a different relationship with, for instance, the idea of justice. Why? Because it's based on, or at least it's founded on, so-called norms of the positive morality of the group. We understand use in a different way that we understand lex, and I can explain this a bit more in the Q&A. So, how does this fare, and this is the second and final point, how does this fare with the, within the dialogue and conversation and challenge between so-called legal and political forms of constitutionalism? I see my account as raising two problems for legal constitutionalism. The first one, I have no problem in saying that. In my view, legal political constitutionals, people like Jeremy Waldron, people like Bellamy, they misunderstand or misrepresent the UK common law model of constitutionalism. They claim that the UK common law model is the embodiment of the idea of the political constitution, of the absence of overarching legal limits to what Parliament can do, you know, the doctrine of parliamentary sovereignty. To me, this is wrong. It also makes me think about you know, the invisible, I've called it the invisible hand theory of constitutionalism. If you read Waldron or Bellamy, very often you get the impression that everything will fix itself in the common law model. Basically, that we don't need an entrenched constitution and judicial review, because in the end there will be elections every 5 years, and the voters know better, and they will fix things. To me, this is also problematic from from a mere terminological point of view. For me, if there is no notion of limits on the authority of the legislature, whatever that legislature might be, it's cannot really be characterized as constitutionalism. I also think, and this is not something that is very popular, but I also think that the conceptual category of political constitution is not very helpful for those of you that are familiar with it. If not, more than happy to go in the Q&A. I think that we should understand political constitutionalism as a much necessary position or attitude that underscores the relevance of political conventions, of non-formal rules for the existence and the welfare of constitutionalism and the capacity of constitutionalism to sustain itself. But I don't think that that is a model of constitutionalism that is viable. Now, the second problem, and I'm going to conclude with it, it's even it's even deeper in my view. And I want you to look briefly at this passage by Jeremy Waldron. The written formulation of a Bill of Rights also tend to encourage certain rigid textual formalism. A legal right that finds protections in a Bill of Rights finds it under the auspices of some canonical form of words in which the provisions of the bill are enunciated. This is the crucial passage for me. One lesson of American constitutional experience is that the words of each provision tend to take on a life of their own, becoming the obsessive catchphrase for expressing everything one might want to say about the right in question. Basically, Waldron is saying, look, just have a look at the US federal constitution. It's clearly undeterminate, which means that the US judges, the US Supreme Court, they can say whatever the heck they want when they are interpreting the Constitution. This is a strong argument. I mean, Waldron, if I'm not mistaken, if I haven't missed one, repeats it verbatim, this passage, in at least 3 works, including his famous article on the court case against judicial review. This is very problematic for me. It's very problematic because what political constitutionalists like Waldron and also Bellamy, a bit more implicitly, they seem to draw a qualitative distinction between ordinary and constitutional adjudication. They seem to be saying, look, we are fine with ordinary adjudication. Actually, the rule of law is a clear foundational element of both Bellamy's and Waldron's theory of the state, of political associations, and so forth. But constitutional adjudication is completely different. It's indeterminate, and we don't want strong judicial review. This is problematic for a number of ways. First of all, we have empirical evidence that constitutional and ordinary legislative norms are much more alike than what they're willing to recognize, especially nowadays. I can point you in the book, I point to the work in which this empirical evidence is put forward. Also, another problem, and this is, I think, is one of the biggest issues in contemporary comparative constitutionalism and constitutional theory, is that the paradigm case of legal constitutionalism is always taken to be the US federal constitution and the US Supreme Court. That is problematic. I would never use the US Constitution and the US Federal Supreme Court as the best examples of legal constitutionalism. So in this respect, in my view, what Waldron and Bellamy and other political constitutionalists do, they commit a one-theory-fits-all fallacy. They think that because they are right on the US constitutional system, that applies to every other system. And in my view, that's simply not the case. We have constitutional systems outside the US that are much more determinate. I mean, the text of the Constitution is much more determinate and much more similar to ordinary legislation than what Waldron and Bellamy recognize in the theory. So, and this is the conclusion, In my view, political constitutionalists end up in a conundrum because as long as they maintain a theoretical distinction between the judicial application of constitutional and ordinary norms, they are implicitly undermining two fundamental elements of their own theories: democracy and rule of law. If, on the other hand, if they were to acknowledge that the difference between the application of constitutional and ordinary legislative norm is not different in quality, but at most in degree, then this key element of their attack on legal constitutionalism, of the idea of strong judicial review, would basically lose most of its bite. It would apply to the US, yes, but it wouldn't apply to other jurisdictions, Italy, Germany, and so forth. So yeah, this is it. I hope I was on time. I will stop sharing my screen, and thank you so much for listening. And welcome, and it's good to see Professor Jovanovic.
Thank you, Paolo, for a great presentation and for sticking with the time we have usually at our disposal. I told you all about my technical limits with WebEx on my iPad, so Anna will help me with all the raised hands and questions, because I can't see the raised hands on the same screen that I can't just share the screen. I can't explain it technically. So for all those of you who have received and read the chapter, you probably noticed that in line with the initial part of his presentation and with the wish to make the content available to as wide as the audience as, which is a noble wish, just not to repeat hopefully not the noble dream thing. Hopefully, I don't know if Bloomsbury sends the data about the sales, or just after 6 months or a year. But I certainly hope that you will succeed in your effort to make the important philosophy of law topics available to the wider public, which is what we usually strive for. I mean, at least some people, at least us in Belgrade, are trying to do that. So I open the floor for questions, and please keep you can, and I can repeat it, you can raise your hand by hovering or something like that over your name in the participants list, and raise your hand. So 3, 2, 1, and I'll start abusing my position of moderator and start asking the questions. Okay, Sava beat me to it before I ask the questions. Sava.
Yes, thank you.
Yeah.
Thank you, Paolo, for the presentation. It was actually, I've read only the second chapter of the book, so maybe I'm missing the whole idea or some of the arguments, if they're interconnected, and if it's important for me to understand the whole chapter based on the book. So what was interesting to me is the idea, which you've emphasized a lot of times, that in order for constitutionalism to exist, there needs to be a legal limitation of legal acts which are enacted by the parliament as a body which is a representative of the will of the people, which is basically from the perspective of democracy. Although I do understand the idea in the common law system, which is based on customary law and something which has a different source from the usual enacting of legal acts from the parliament. What I'm interested in is the case of our tradition, European or continental, which doesn't have such an emphasis on common law or customary law, but rather has in most states, some sort of a judiciary review, which is actually, it seems to me, maybe I'm mistaken, but it seems to me problematic because that review is based on a constitution, which is also in most times, in most cases, enacted by the parliament. So is it a different source when it comes to the judiciary review in our legal system? And does that fulfill the condition of constitutionalism? Because it seems to me it's also based on an act which is, or should be theoretically, something given by the people or by their representatives. So is it a completely different system based on these assumptions, or am I mistaken? Thank you.
You are not. Thank you, Sava. No, it's a very good point. You're not mistaken. In the book, I'm assuming that whatever entrenched constitution there is in a system, that constitution will draw its legitimacy from the people. And I'm thinking about the case of a constituent assembly. Look at the Chilean case, what's going on right now. So to me, that is the paradigmatic case of, you know, an entrenched constitution. An entrenched constitution must have that kind of popular legitimation, so to speak. But what I was trying also to highlight is a different thing. Even when a constitution is, so certainly I agree with you that if a constitution is merely, well, let's put it this way. If a constitution is approved by parliament, by a parliament, a legislature, that has been directly elected democratically, then it will not have the same direct legitimacy of a constitution that is approved through a constituent assembly, perhaps, but it won't be that far off. Most of the time, actually, new constitutions also require a constitutional referendum for approval. And so that might also give the legitimacy in that respect. But what I'm trying to also underscore is that in my view, I might be mistaken, but in my view, even entrenched constitutions are a form of use, are a form of law that is somehow different from ordinary legislation. And one thing that I would like to write when I have time, and at the moment I haven't, but I think this will be a natural byproduct of the thesis in my book, is the following. One of the biggest jurisprudential problems that we all deal with, you all have dealt with, you know, while you were teaching, while you were studying jurisprudence, is the relationship between law and morality, law and justice. And we have read a hell of a lot of, you know, books, articles on the relationship, Alexi, positivism, inclusive, exclusive, blah, 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 blah. But what if we have been talking past each other for a long time? Because in reality, there are two types of law that have two different relationships with morality. In my view, lex doesn't have any necessary relationship with morality, because lex is the product of political authority. And we know that parliaments can pass evil laws. We know that it happened. So there is no denying that. But when it comes to use, that I think there is a difference. I think that the idea of use, this different type of law, has a more direct connection to morality. And it's funny because Hart hints at this in the concept of law, but doesn't quite get it right. Funny enough, John Gardner in Law is a Leap of Faith, he hints at this building on Hart, but I think, again, doesn't quite get it right. They basically think that these are two opposite understandings of law, whereas to me, these are two complementary senses of law. So yes, you're right. Democratic legitimation absolutely is relevant, of course, but there is also, to some extent, how can I put it? There is also a sense in which we expect constitutions to be certainly more just than what we expect ordinary legislation. Ordinary legislation, we know that ordinary legislation can be evil, you know, can discriminate, whatever. But a constitution that discriminates, so in this respect, I think Alex is right, but only when it comes to use, not when it comes to lex. I'm trying to underscore this point. I would like to write an article about it, but I haven't had the time yet. I don't know if this answers the question or not.
Yes, but I still have some doubts about it because it seems to me I can't completely grasp what that use could be, because there is no certainty that it will have a different outcome or a different set of values, even though it has a referendum, even though it could be enacted by the people by themselves.
I agree
It
with
seems
you.
to me that constitution.
Sorry, I agree with that. I'm not saying that it's always the case that, you know, that happens, but what I'm saying is that we expect, there is an expectation that a constitution will embody certain values based on the history of the place, of the population, etc., etc., as well.
Okay. Yeah, thank you.
So thank you. We have two questions lined up. The first is from Miodrag Jovanovic, and the second one is from Teodora Miljojkovic. So let us. Is this okay, Paolo? So if we just you answer directly after the question, or should we? Okay, we'll try answering directly after the question. Miodrag.
Hi, Paolo. We are sitting in the same room. There is some problem with the sound.
So let me mute myself.
It makes you even more authoritative, Miodrag.
You mute yourself and not let me. Yeah, go. You mute yourself. Okay, now try speaking to see if Paolo can hear you.
Via your mic.
Yeah.
Can you hear me, Paul? So and so.
Speak.
It's weird. Yeah, we are just sitting across each other. So, first of all, it's very nice to see you, although it would be much nicer to have you here in Belgrade, but hopefully somewhere in the autumn we'll find some window to bring you here in Belgrade to properly present your book, which will be probably sold by then. And I'm just interested in kind of maybe it's a clarification or just to contrast the frameworks for discussing this issue of creation and application of law. If you compare your framework to Kelsen's framework, because you do not refer to him in this chapter 2, at least not specifically to his very prominent claim that basically everyone is creating, including the judges, everyone is creating law, and the only basically actor, state body, which is not creating is the one who is undertaking some material action, or if it's a individual actor or citizen at the end of this chain. So if you take this very simple claim, which comes from Kelsen's dynamic view of the legal system as such, how would you consider your claim, or would it be the same sort of the claim, or it's obvious that you want to highlight a different thing, but I'm interested whether you can rely in this respect on Kelsen, or it's different, and if it's different, in what way it is different. That would be my question.
Thank you, Miodrag. So I discuss Kelsen in chapter 6. There are about 5 pages in which I basically take the general theory of law and state, which is where he discusses most prominently the distinction between creation and application of law. And I try to criticize Kelsen in 2 ways. The first one is, and I'm saying this especially for those who might not have read Kelsen on this point, Kelsen, as Miodrag said, says, well, you know, every act in the legal system is ultimately at the same time an act of creation and an act of application of law. The only exceptions are the first immanent act at the top of the legal system, the constituent act, or whatever is there. But when it comes instead to pure application, Kelsen says it's literally only those acts of execution of the sanction. So Kelsen is basically thinking about the police officers that bring the person convicted inside the jail, the cell. And for Kelsen says that is the only real action of pure application of law. So I criticize Kelsen in 2 ways. The first one is to show that, so for Kelsen, all judicial decisions also create the law because they create an individual norm. And so for Kelsen, every judicial decision creates a norm, thus is creation of law. It's an act also of creation of law. This has been criticized way before me by Buligin, by Guastini himself, by Ferraioli, and I basically just draw on their work to say that from an explanatory point of view, what Kelsen says really doesn't make much sense. Because if every judicial decisions always creates the law, because at a minimum it establishes an individual norm, then we have no way to distinguish between those judicial decisions that apply a pre-existing norm to a factual situation, and instead those judicial decisions that come up with a new, either wholly or partially new norm in deciding a case. So imagine any, the famous judicial decision in Donoghue versus Stevenson in the UK, in which the court put forward the neighbor principle. This is tort, for those of you who are not familiar with the matter. If we buy Kelsen theory, then we have no way to say that this was actually a decision that had a really creative element, because it created a new norm or a new principle in this respect. Second, when it comes to application of law, and in here I agree with the criticism of Kelsen of one of our very good and common friends, Pierluigi Chiassoni from Genoa, when Pierluigi says, look, Kelsen is actually an extreme legal realist, because Kelsen says, well, there is a frame of reference of meaning of the norm, but inside that frame, whatever goes, because in the end it's the judge that decides the meaning. And so actually, if the judge goes even outside the frame, we must, because legal science is pure, we must just say that, that's the meaning of the law, that the judge can basically just go inside. So Kelsen is very, and I've been discussing with Stanley Poltz on this aspect, and Stanley, of course, he tends to defend Kelsen on the point, but in the end, I think he acknowledged that Kelsen ends up being a legal realist, and an extreme legal realist, almost a la Michel Troupert, whatever, because he says, everything goes in the end. Yes, there is a frame, but in the end, it doesn't matter. So in chapter 6, Kelsen is one of the main departure points, and I try to show that he's wrong on both counts. And I try to put forward a model of application of law that is complex enough to basically be used in our modern legal systems. Whether I manage, I'm not sure, but the attempt is there.
Thank you, Miodrag and Paolo. We have now 3 registered questions. We'll go in this order. We'll have to gather them because of time constraints. So Teodora has the first question. Alexandra Prelevich Paladino has the second question, and Nikola Cvetkovic has the third question. Go, Teodora.
Okay,
Now,
I could have gone last. Thank you. Do you hear me?
yeah.
Okay, good. Thank you. Thank you, Paolo. Hi, Paolo. Thank you for your presentation. So I will be just short because I'm not sure that my question is actually appropriate in this discussion. But as someone dealing with constitutional law, this is what first came to my mind when I listened to your presentation and when I read the second chapter. So my question is, what do you think? Like, what is your opinion based on this differentiation between and the need of differentiation between the creation application of law? What is your opinion on the recent jurisprudence of certain apex courts on constitutional amendments? So do you think that so how does that interplay in this specific framework? Because I would say that's a I mean, you discussed with Sava the constituent power. So here it is some kind of expression of a constituent power, but not by people, but by the court, which protects it. So, like, how do you think that this is related? So that's just my question. Hope you understand it. Thank you.
Okay, Alexandra.
Hello to everyone. Actually, I would have two short questions. One would be, let me see, constitutionalism as a legal otherness. This term I found very interesting. So I would like to know more about your opinion about this term. Is it the best one, or constitutionalism would should rather be a normality, not otherness? You know, something like that. Then the other question would be, am I wrong, or if I had this impression that in a way constitutionalism in this English world would be less, in a way, something less. If we, how should I put it? If we think about this thing that that you said before, that if there is a referendum about the constitution, it somehow gives you know, something to this term, to the concept of legitimacy of the constitution. So I would like to know your opinion about some criteria about the higher level of legitimacy versus constitution in a situation where we have where we use the referendum as normal thing, or the UK example. If you can show me, tell me about your vision about the level of legitimacy in these two different constitutionalisms. Let's say something strange, but you know, two concepts completely different. But is one of them less constitutional from your point of view? This is.
Okay, thank you, Alexandra. And we have a question from Nikola. Nikola, go unmute yourself.
Hello, can you hear me?
Yep.
Excellent. So, Professor Sandro, let me just turn on my camera here. So, thank you for the lecture, and I will try to be as concise as I can and ask you a question which I hope is within the matter of this lecture. So, would you say that the acceptance of these conventions you mentioned, these legal political conventions, are key for the success of constitutionalism in both Anglo-Saxon and continental legal systems. And why do I ask you this? Because I'd say there's a problem in general across the world where we have certain nations whose populations aren't very keen on getting interested in legal matters, in political and legal culture. And because, for example, in my high school, we once had a discussion in our philosophy class about whether some nations are bound to remain under autocracies and others are bound to remain democracies. And a parallel was brought between Sweden and Russia. For example, I argued that Sweden also in the past had to fight for its democracy, that it also was at some point in its history autocracy, and that the key problem it had to overcome so it could become this democracy and an ideal, an utopia of sorts, is that the Swedes accepted the values of legal conventions of political theory, legal theory, and so on and so on. So I hope that I didn't talk nonsense now. So in short, what do you think is key for the success of political legal constitutionalism? Thank you very much.
The students haven't surprised me, but have taken away a lot of time that I wanted to use to ask questions to Paolo, and who admittedly is tired, but I still have to use the time to shoot 2 questions. And I'll try to be short, especially with the first one. I sympathize a lot with the idea that there isn't a qualitative difference between constitutional and ordinary linguistic formulations, let's say, or legal texts, in the following sense, that I would tend to agree that it is a difference of degree. But what I found interesting is that you at one point mentioned various kinds of linguistic indeterminacy when it comes to constitutions and statutory texts, and you lump them together, and it's even in brackets, like a couple of them, and you put 3 dots. I was thinking about, it made me think about this possibility that actually one could make a case for constitutions being filled with a specific kind of indeterminacy related to the essentially contested character of constitutional terms. And we couldn't, I mean, they would of course be present even in statutory text, especially in the first parts, depending on the drafting style, where you have the principles part, but the constitutions usually are, and I know that you mentioned some recent trends in constitutionalism, in written constitutions, that emphasize clarity and concreteness of constitutional language, which is a move in that direction. But it would seem to me that, for example, it arguably one kind, or at least a couple of kinds of indeterminacy would be specific, also as a matter of degree, of having it much more in constitutions. That is my first question. The other question is, and I'm sure that it's only related to this paragraph and it's this chapter, and it's explained in detail in the 3rd probably chapter, where you paint the picture of legal realism and formalism and differences between them. But I still have to ask, because a couple of statements seem to me to favor a radical version of form of realism that would be like Jerome Frank, eventually version of formalism, and not close to what I take to be the most prominent representatives of contemporary legal realism, Leiter and Guastini, it would seem to me. So Leiter has this idea of the like class of legal reasons which cannot justify just one decision, or in a certain number of cases an appellate court that reach appellate courts. And Guastini has this arguably a more radical idea that the plurality of meaning always leads to a choice of the judge, and that choice of the judge, the normative choice, constitutes what we usually call creation of law, in a certain sense. I mean, not ex nihilo, but from the possible meanings of a legal sentence, or at least the plausible meanings of a legal sentence. What I take that to mean, and I'm now being too maybe legal philosophical and less constitutional, what I take that to mean is basically something that could be a thought with your thesis in this chapter. The idea is mostly, in my interpretation and in my understanding, that not that the law is indeterminate, full stop, but that the amount of determinants or the class of determinants are far wider than the class of linguistic determinants of law, if I'm making myself understood. And in a couple of passages you mentioned the importance of it's not of formalization, of formality of constitutions and statutory texts. And by formality, for the most part, the way I understood it, you mean the written form of the constitution or the statute for that matter. And it's just how I understand the contemporary, at least realist idea, is that the set of reasons that determine the meaning of a legal text leading to a legal norm cannot be confined to the linguistic reasons. Of course, this would depend, and I'm sure that you will be able to answer it. It would depend on your construal in the further chapters of legal realism.
Okay, so I think I have 5 things to address, so I'll try to do justice to each and every one. Theodora, thank you for your question. Very good one. The honest answer is, I think it really depends on context. One of the messages that I would like to send with this chapter in particular is that constitutional theory must be careful about the context, and there are very few universal things that can be said about constitutional theory. That context affects it's something that we should take into account in our theory. So when it comes to constitutional or unconstitutional amendments, it could be argued either way. It could be argued that the Supreme Court, a constitutional court, declaring a constitutional amendment as unconstitutional is an usurpation by the court of the constituent power. But to be honest, that will depend whether or not that amendment has gone through a referendum, for instance. If that amendment has only gone through a procedure by parliament but not by a referendum, then a case might be made that is less legitimate. But I do take the point. On the one hand, I take the example of the Italian constitution. Formally, the only thing that cannot be amended of the Italian constitution is the republican form of government. That's the last article of the constitution, of course, after Mussolini, fascism, etc., etc. But the court, with time, has expanded the unamendable provisions. And so, for instance, they say that the rights in Article 2, the fact that Italy is a republic that doesn't discriminate based on the sex, gender, race, blah, 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 cannot be changed by any majority. Do I see that as problematic? Not so much, but I do understand that. So here it's also a matter of the of the self-reflexing understanding of the court. The more the court expands the area of unamendability outside the formal terms of the Constitution, and the more the court is doing something that is problematic from a legitimacy point of view. But the more, if it's only about a core of basic principles, then I don't see that as particularly problematic in this respect. I see that problematic if it becomes regular, and if it goes beyond what basically everyone agrees. Everyone in Italy would tell you, that yes, our constitution should have those values. But of course, if the constitution were to go beyond that, if the Constitutional Court were to go beyond that, then a question of legitimacy of such behavior by the Constitutional Court should be certainly asked. So I think it very much depends on context. But think about this, and I'm going to stop with this. The Constitutional Court in Italy, for instance, to me is very interesting because they're also very respectful of Parliament. In Italy, there is a discussion about euthanasia for years now, and the court was asked to pronounce on the topic and was asked to say, you must decide that according to our constitution, there is a right to assisted suicide, blah, 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 blah. And the court said, we can't say that. That is for Parliament to say. There is a legislative vacuum here. We cannot fill that vacuum. And in that way, they showed deference to Parliament. You see what I mean? And I think that that kind of dialogue is important. This is why I say context is important. It will depend on how each constitutional court has developed their own approach towards their parliament in the domestic legal system. So Alexandra, thank you for your 2 questions. The first one, legal otherness, if it's the best word, I don't know. That's the word I came up with after many sleepless nights. But what I mean by legal otherness is this. In my view, in a constitutional democracy, there must be a duality of law. There must be 2 types of law, not just one. If you are in a state where there is only one type of law, the law of Parliament, the law of the king, the law of the dictator Rex, then it's not really a constitutional state. In order to be a constitutional state, there must be 2 types of law, with the second one that either formally, in the model of entrenched constitutionalism, or pragmatically, which is the UK model, provides limitation to the first type of law. And this goes to the second question, is one model less constitutional than the other? When I moved to the UK, I was certain about that, Alexandra. I was like, my God, how do they do this? These barbarians, they don't have a constitution. And then I realized actually that they were the first ones, at least after the Romans. In the book I discuss the late Roman Republic, but certainly the UK common law is the first clear attempt at limiting the power of the sovereign. And how do they do it? Of course, there is no strong judicial review. They cannot annul legislation, but they can set, they did historically set it aside in some extreme cases. Or the way that they do it more often is through interpretation. They say, we are interpreting the will of Parliament, but in reality, they're changing the meaning of what Parliament said. Parliament, this is the issue, for instance, of ouster clauses in UK constitutional law. It's very clear to me that what they're doing, they are performing strong judicial review. They're just cloaking it under a different language. We are respecting parliamentary sovereignty, but in reality, they are using interpretation to change the meaning of legislation. And that means that there is a form of limitation. Nicola, conventions. So conventions are crucial. The way that conventions have been understood in continental constitutional theory, I think one way is through the idea of the material constitution. This is an idea that an Italian constitutional lawyer, Constantino Mortati, made famous in the first, in the last century, let's say. And now this idea of the material constitution is being pushed out again by a very good friend of mine, Marco Goldoni from the University of Glasgow, by Mariano Croce. There is a new wave in in understanding of the the material constitution. The substance is the same. Conventions are fundamental. In the UK model, they're more prominent. Right now in the UK, what we're witnessing is conventions are crumbling, and because we don't have an entrenched constitution, the situation is really bad. If you are in a state with an entrenched constitution and a strong constitutional court, imagine Italy under Berlusconi, for instance, 20 years, 15 years ago, then you might have a sense of convention eroding as well, conventions about public life, standards, and so forth, but you do have that kind of safeguard. It might not be enough, of course, as we saw, for instance, in Poland. And as to the question of autocracy and democracies, I honestly don't know, Nicole. I'm sorry to disappoint, but that's a question that requires sociological work, anthropological work. I'm not sure whether some countries, it's a discussion that I have very often, even at home. My wife, she was born in Ukraine. And you know, it's something that we discuss a lot in talking about Russia, Ukraine, the European Union. I don't know, to be entirely honest with you. Finally, Boyan, your first question, I got it, and you might be absolutely right. There might be some specific indeterminacies that are perhaps unique. You want to say, shall we say, perhaps even some rights, because they're so morally laden, then of course some rights might be unique in this respect. And in fact, in the book, I say, look, on these matters, the court should find an approach that is, you know, is moderate, that should understand that there can be legitimate different views in some outside the core of certain rights. The second question, I wasn't too sure, in the sense that I'm not sure what you meant talking about the different types of legal realism. So
it just seemed to me that a lot of hinges on the linguistic expression of the constitution or the statute in this chapter, and that was a question basically about it. It's to simplify it completely, like is what I consider to be a realist issue, at least contemporary realist issue. I mean, as a position in adjudication, not this conceptual construction of the entirety of the legal system, is that the quarrel is basically, if you exclude Dworkin, of course, as a possible formalist. The contention is that the formalist claim is that law is linguistically determined. And the realist claim would be, oh, it's not.
Well, I understand. So here I'm talking primarily against people like Waldron. Because for Waldron, the argument from linguistic indeterminacy, and not just Waldron, this is a very big argument for all the people that are the judicial review skeptics. I mean, Theodora, you know, is working on this stuff, and all these people, one of their main arguments is, well, you know, the text of the Constitution is indeterminate, which means if there is strong judicial review, the judges are the sovereign, and it's, you know, it's not anyone else. But the reality is very different. The reality is that these people are totally fine with judges decided as indeterminate or underdeterminate concept in ordinary legislation, but not for for the Constitution. And also constitutions have become closer to ordinary legislation then. So this is also the problem. Let's stop using the US federal constitution. US federal constitution is the wrong example. It skews the analysis, it skews the discussion. We should avoid talking about it altogether.
Thank you so much. I think that everybody, and you can see the interest by the amount of questions, and I'm sure that there would be further questions if the time we usually allot for these events was longer. On the other hand, I'm sure that we'll have more time in the autumn, hopefully. I mean, but the way things are going now, we're just we're just falling from one cliff to another. Hopefully the downfall will stop eventually, and like the things will start resembling, at least remotely, some kind of a normal situation that we had like 5 years ago or something like that. But I won't go into dark places with this, because the presentation was wonderful and the answers were great, as well as the questions. So I thank you so much and hope to see you soon. Hopefully you'll visit Bucharest, at least for the IVR. Yeah, everybody's thinking about it in various ways, but it's autumn at the latest. Thank you once again, Paolo.
Thank you all, and especially to everyone for taking the time. And any question, please just drop me an email. I really appreciate that. So thank you guys, and hope it was interesting at least.
For those of you willing to spend the money on Paolo's book, which is totally worth it, yeah, I'll shoot you an email when it becomes available in the library of the Faculty of Law, University of Belgrade. Order 2 copies just in case, so that I can keep one in my office. But the other one you can rent and read. Thank you so much. It was a great seminar. Hope to see you soon. Again, physically, not via a computer screen.
Me too. Thank you very much. Thank you, everyone.
Era un vero piacere.
Grazie. Ciao. Thank you.
Very nice meeting you. Bye.
Bye bye. Thank you.